become one of the main topics, but also one of the most requested topics by our audiences. Lots of you are trying to pursue that H-1B lottery, and then we know that it's not getting any easier during these years. And then one of the options that a lot of students are trying to explore during their OPT years is that those H-1B cap-exempt rules, how could they get H-1B and what kind of rules are there? So today we just wanted to invite two experts from their field who knows a lot about H-1B cap-exempt, and then they're going to do a presentation. I'll also later going to let them introduce themselves. We're going to talk specifically about H-1B, about OPT F1 transitioning to H-1B cap-exempt, about some of the qualifications, proofs and stuff like that. And then also we're going to discuss concurrent employment strategies, how to actually get H-1B while that you are employed by multiple positions, you're working on multiple roles. And then also we're going to discuss briefly about sponsorships and self-sponsor possibilities. And then on the second half of today's webinars, we're also going to have a live Q&A. So you're welcome to send your questions if you have come in prepared. Send your questions into the Q&A box down below. So our coordinator here, Shama, is going to collect everybody's questions. We're going to put them into a sheet, and hopefully we can answer as much questions as we can with our guests, Rauhmel and Antonio, here today. So just a little bit about who we are as the host of today's event. We are headquartered in Los Angeles. We're an education consultancy. We mainly work on hybrid programs, CPT programs. We work with universities, and we are certified by AARC as one of the biggest, most respectful educational industry. We have two upcoming campaigns. One is our reward program. So if you enroll in one of our schools, you can join the programs. You can earn points that can translate it into credits through your site. So definitely feel free to check them out. And then we host sessions just like this with industry experts, with universities every week. So feel free to go to goelite.com/events to check out all of these latest events. And then if you wanted to learn more about CPT, learn about the universities, feel free to check us out on Google Maps as well. We currently have lots of Google reviews about our consultants, about our services, and then last is just our social medias on every platform. Feel free to check out more in all of our platforms, including to English platforms and Chinese platforms as well. And without further ado, I will stop sharing, and then I'll let our guests briefly introduce themselves and start presenting.
Thank you, Ryan. I welcome everybody. I'm just going to dive right into it. For many of you, this journey began with a simple idea to study in the United States of America. And as you can see from the signs in this photo, that's just the beginning. The real innovation starts when you take the next step, which is to incorporate your own U.S. employer. And that's what we're here to discuss today. But you can transition from an F1 student status to the CEO of your own U.S. enterprise and the beneficiary of a petition for status change.
So the information we're about to share with you, get on my screen. Oops. So the information we're about to share with you is a result of years of research. I've been doing this since 2005. We are providing it in this forum as a courtesy to Go Elite and its customer base under the banner of fair use. So you're welcome to use this information. You can talk about it, comment on it, and so on. Since this is an educational setting, we wanted to give you specific information, instruction, and scholarship so that you can improve your scenario.
And what we are discussing is a specific method and process. Under California Civil Code, this constitutes as a trade secret because it derives independent economic value for not being generally well known. And we take reasonable efforts to maintain its secrecy. We are sharing it with you today within this confidential educational framework so you can achieve your goals.
So who are we? So want to outline one thing. We are on a list of what is called providers who can assist you or represent you with a private immigration matter. We are reputable individuals. However, today we want to clarify that we are not in that capacity today. So the list can include attorneys, law students, and others, but part of that list includes reputable individuals, myself and Antonio. However, today we're not doing that.
Yeah, that's correct. Although we are on the list for reputable individuals, today we're operating as top executives of our respective 501c3s. Title 26 of the Code of Federal Regulations, or CFR, defines accomplishing a charitable purpose as an effort to contribute to your advancement of education. Our focus then, just like a superhero, is to defend your human and civil rights secured by law. Since 1958, the precedent was established that a foreigner could own a duly incorporated entity and be the beneficiary of a petition.
So that's a charitable purpose. And then the educational purpose defines it in two ways. We can provide instruction or training to improve or develop your capabilities. In this case, for you to consider incorporating your own United States employer to petition for H-1B Cap-exempt on a part-time basis, and then to qualify for concurrent employment on a full-time basis with any other petitioner. The H-1B program is widely discussed throughout the world recently because of recent presidential proclamations and other orders. For example, Presidential Proclamation 10973, and then also the gold card that is asking people to donate $1 million to the United States. So our role today is to instruct and train each and every one of you to consider the possibilities.
Okay, so my name is Antonio Mendieta. I am the principal instructor for CEO intern. My corporate focus is on cultivating future leaders. As F1 students, many of you are already familiar with the concepts of practical training. You're authorized to participate in part-time or full-time CPT, pre-completion OPT, and post-completion OPT. My organization assists with developing your potential by providing instruction for you to manage your status as a self-employed business owner. In my official capacity, I supervise the training experience for STEM OPT students, as well as fully adhering to the USCIS Chapter 5 guidelines on practical training. I also supervise unpaid volunteers and/or unpaid interns, ensuring the practice is compliant with all California and federal labor laws, consistent with SEVP policy guidance. My personal motto is greatness isn't found by asking what if, greatness begins by declaring, I am making this happen. The certainty of your ambition changes the reality you live in.
As for me, my name is Rauhmel Fox. I'm the principal instructor of H-1B CEO. My focus is on the next step in your journey. As an F1 student or OPT, day one CPT, whether it's part-time or full-time, pre-completion OPT or post-completion OPT, you have different options to maintain your status. But then what's going to come next is the opportunity for H-1B Cap subject or Cap exempt. In today's session, we will not cover H-1B Cap subject because that was exhausted or reached the limit on July 18, 2025. So for today's discussion, we're focusing on H-1B Cap exempt. Like Antonio's program, my tax-exempt organizations provide fee-based services as well. I also supervise volunteers and STEM OPT students to do their training. I can file the Form I-983 with the DSOs. So our goal is straightforward, to instruct you on how to form your own H-1B Cap-exempt employer. Today, we're going to give very specific information that you can take today to file and create your own entity today. DHS explicitly encourages you guys to participate in the H-1B program by filing a petition with your own organization and being the beneficiary of that petition. H-1B Cap-exempt employment authorization is immediately available and unlimited. So if you know of someone who could benefit from this orientation, we'll facilitate additional pre-incorporation training. I'll be available during LA Tech Week this Saturday, October 18th from 10 to 12, and then every day of SF Tech Crunch Disrupt, October 27th through the 29th. And then my motto is vaticinate responsible success. So let's forecast your success together.
So let's take a look at the unlimited pathways for non-immigrant entrepreneur employment available to you in the USA. Many of you have probably heard of the O1A classification for extraordinary ability, which sounds prestigious, right? Let's take a look at the actual definition from DHS. It requires a level of expertise indicating that the person is one of the small percentage who have arisen to the very top of the field of endeavor. And that is a high bar to clear. It's designed for a tiny fraction of the people. Now, let's consider the H-1B non-immigrant classification. It is designed for entrepreneurs who possess highly specialized knowledge obtained from a U.S. degree or its equivalent. You are here because you have or are about to have a U.S. degree. This pathway is for professionals in a specialty occupation, and it was designed for you. The H-1B is not about being at the absolute top of your field. It's about completing a precise and specific course of study that your degree represents.
So that leaves you with a choice, and they're directly opposite each other. O1A is actually subject to additional ties to your country. You must actually prove non-immigrant intent with that particular category, whereas H-1B is pure dual intent. So the O1A and the H-1B Cap-exempt are both pathways available to you. The critical distinction lies in that O1A is subject to strong ties and proving that to the U.S. consulate. So you can be approved in the United States. However, if you get an EB, employment-based visa, and you go back to your country and ask for a visa, although the petition itself is not reasons for denial, but you still have to meet the criteria for strong ties to your country and other reasons that you would, not immigrate to the United States. So as you can see, and there's a rule called the Foreign Affairs Manual. It discusses that you can't abandon your ties. So basically, that leaves the primary pathway, and Antonio is going to discuss that for you.
Yeah. As you can see with the data, for every petition approved for O1, there are 14 approved for H1B, which makes it without a doubt the primary pathway for non-immigrant entrepreneur employment in the U.S. The legal basis for this is found in the Immigration and National Act, or INA Section 214G5, or even Title 8 of the United States Code Section 1184G5. This states that the numerical limitations, or the cap, do not apply to a non-immigrant entrepreneur with a U.S. degree who has received an offer of employment at a nonprofit research organization. DHS has affirmed this, as you can see in text at the bottom, stating it seeks to encourage more entrepreneurs to use the H-1B program. This isn't a workaround. It's the intended function of the law.
So let's be clear about the government's position. This particular image just shows you the different pathways in terms of being a non-immigrant. Obviously, we depicted it where the best option or the wide open door is H-1B cap exempt. Again, it is unlimited and immediately available. Whereas cap subject, there are 58,200 visas available. There's additional ones for Singaporean or Chilean citizens. But again, it's only available in March. And if you are accepted for that, the petition is due by the June 30th. And if that is approved, then you would have a work date starting on October 1st of the following year. Again, H-1B cap exempt is available right now, and it's only available for a certain type of employers. And that's what we're discussing today. So this is also based on a new change that was effective on January 17, 2025. DHS is specifically putting it in the rule that foreign nationals can form their own employer and submit a Form I-129 petition for themselves as a sole beneficiary. So a common question that we often get is, well, can my own employer petition for me? Yes, that's been established since 1958 and been reaffirmed in 1980s that a corporation, even if it's owned or controlled, we're going to discuss creating a nonprofit organization that is recognized by the IRS as tax exempt to claim eligibility as a nonprofit research organization. And that can be operated by a single person. That entity may hire you. You are the official. You're able to sign the documentation. And then the parties, yourself, the entity, technically are in a relationship together. And because of the new change, the USCIS no longer focuses on the control of the employer-employee relationship. So your ownership of the petitioning entity or control of it is no longer a proper basis for denying that petition. So the legal precedent has been firmly established and reaffirmed over and over again.
Bringing this back to your current status, this picture is intentional. The message behind this is for F1 students. USCIS has stated in no uncertain terms that F1 students, you may start, own, and work for your own business during your initial period of OPT. DHS has even acknowledged that entrepreneurs might be reluctant to participate because of an old memorandum that created confusion. They all They are actively trying to correct that misconception, particularly about the employer-employee relationship. USCIS no longer focuses on control. As a result, you can choose to begin this process right now, before graduation, or while on OPT or STEM OPT. You can lay the entire foundation for your H-1B Cap-exempt petition before your F1 status even expires. And in turn, you will be able to generate evidence to seek classification under EB-1A.
So I want you to consider this question. There are approximately over 1.3 million F1 students in the USA right now, whether F1 student status, CPT, part-time or full-time, pre-completion OPT, post-completion OPT, and STEM OPT. That's a lot. So I ask you, what would happen right now if every single one of you formed your own United States employer in a day? I contend that taking such action would unleash a new wave of innovation and entrepreneurship in the USA, the likes have never been seen before. Yes, you came here to learn and you did pledge to return home. However, due to recent policy changes, the pathway empowers you to stay here to obtain H-1B Cap-exempt employment authorization. It's a profound shift in thinking from depending on someone else to sponsor your work authorization to now you actually creating your own employer and you being the C-suite.
Now, this whole image may seem complex, but we have refined it to a 3-step process. Step 1 is incorporation. We instruct on the formation of a Delaware charitable non-stock corporation instead of a California nonprofit public benefit corporation, which requires 2 corporate officers. This addresses fundamental questions like what is the minimum number of incorporators? What about the board of directors? Can the CEO, CFO, and corporate secretary positions be held by the same person? We provide the instructions to navigate these requirements, and executive trainees commit to train for an entire year. But this step can actually be completed within 24 hours. Step 2 is obtaining your Federal Employer Identification Number, or EIN, from the IRS. If you possess a Social Security number, or SSN, this is where you can designate yourself as the responsible party for your entity. For a tax-exempt organization, this is typically the principal officer. To claim eligibility as a nonprofit research organization, you submit an application for recognition of exemption. This process is estimated to take about 22 days from the date of incorporation, but the US government is currently shut down, so you can expect delays. And step 3 is the petitioning stage. This involves submitting the appropriate forms to 3 different government agencies. The Department of Labor for the labor condition application, which can be certified in 7 working days. U.S. Citizenship and Immigration Services for the Form I-129 petition. And finally, the U.S. Department of State for visa processing, if needed. It's methodical and it's step-by-step progression.
So keep in mind, you can incorporate within 24 hours, obtain your EIN within 15 minutes, apply for recognition with the IRS immediately. That'll take some time for the IRS to approve that. However, you can treat your organization as tax exempt while it's pending. And then you can go right away to start preparing the Form I-129. And that starts with filing the LCA first. That takes about 7 working days. And then you can, after you build your packet together, then you can file for premium processing, which means you can get a reply from the USCIS within 15 working days. Well, let's say that it's approved by USCIS. So what comes next? Well, there's something called H-1 portability and concurrent employment. For today's discussion, we're going to use the term outside employment. You're going to have a relationship with your organization on a part-time basis. And then once that is approved by USCIS, an eligible H-1B non-immigrant is authorized to start concurrent employment or employment with another petitioner upon the filing, which means immediately. Now, immediately, if you look at the chart again earlier, it takes 7 working days for the LCA to be certified. And then, of course, you have to then file the petition, premium processing, or on a regular basis. So there'll be some time. So at a minimum, and then you also need 2 pay stubs. So keep that in mind to plan ahead if you want to change the employer or to do concurrent employment. So the key thing here is once you have the approval on a part-time basis, 20 hours or less, then you unlock the opportunity to work for any other petitioner in any varying hours. For example, Maybe you're recruited as the board of directors of a startup. Your knowledge is required for that. That can be considered a specialty occupation. That would be 1 hour per quarter. Or maybe you're doing full-time with the primary target employer that you want to work for. So keep that in mind that with your own organization, you'll be in one industry, but then the next employer, that is where that will control whether or not you can work for other employers. For example, Burger King doesn't want you to work for Wendy's because they're in the same industry, but you would certainly look at your employment agreement to determine what your roles are, whether or not you have a conflict of interest provision or conflict of time, duty to the organization. So keep in mind, the law is silent on this, how many relationships you can have. So you would look at your employment agreement in that regard to see what's going on. Oops. So you're no longer dependent on a single employer. The key thing here is you can control your destiny. Incorporating an organization, again, you can do California. However, California for a nonprofit organization requires 2 officers. Delaware, you can be the incorporator, the sole director of a board of directors, and you can be the CEO, CFO, and secretary, the entire C-suite to sign the documentation. The only caveat is how long it takes for the IRS to approve the recognition for the entity. But once that happens, then it's a matter of filing for premium processing, and that's your particular timeline. The key thing here is it's available immediately, it's unlimited, and you're no longer dependent. And then you can certainly work for other organizations. Again, the law is silent on how many relationships can happen. But again, you'll look at the employment agreement for that. Okay, FAQ time. Ryan,
Okay, thank you so much. Thank you so much for your presentation, Rauhmel and Antonio. Tons of useful information. I think audiences are rather a little bit unfamiliar with H-1B Cap-exempt because you know, most of the time that they're spending, they're trying to study the lottery and then the H-1B cap and everything like that. So everyone, if you do have questions, concerns, you want to try exploring the H-1B Cap-exempt route, please feel free to leave a question. As I mentioned, leave a question in the Q&A box. We're collecting questions right now. We currently have a couple questions that we can get into. Let me just quickly share my screen, and then we will try to address everybody's questions as much as we can.
Sure.
So
Q&A.
Okay, let me share my screen. Okay, let me know if you guys can see.
Yes, I can.
Okay, that's good. All right, let's move on. Question number 1. I would like to know how it's going to be for F1 students to get the H-1B after Trump's new fee of 100,000. I think that was on the proclamation, and
Sure.
I think things are not valid for now. Again, we're not offering any legal advice or anything like that, but just wanted to have you guys' opinion on this subject matter.
Sure. So if you read the Presidential Proclamation 10973, it discusses the future lottery and potential beneficiaries outside the U.S. who might be selected in March. So that group has not been identified yet. There are 2 lawsuits pending to challenge the president's authority to affect a fee associated with that. At this point in time, the proclamation is silent regarding offers of employment at nonprofit research organization. And so right now, for those persons in the United States, the fee does not apply. When you look at the language, it says prior to filing the petition, which is called a consular petition, meaning the petition approval would be sent abroad. Well, for cap-exempt petition, you would already be filing, and so that $100,000 fee doesn't apply. So there's 2 lawsuits concerning that right now. So as of right now, those in the United States, you can go ahead and consider filing your own employer. The ruling that started in January 17th of 2025 has not been rescinded, so keep going with that. Those persons outside the United States, you can still file and create your organization outside the U.S. And still file. If it comes up that the petition will be required, then that will be an opportunity to file a lawsuit.
Absolutely. Okay, moving on. Next person wanted to know, can I start my own company while studying on F1 visa? If yes, how does it work? I think you kind of covered that in your slides, but
Correct.
if you can went into some details, that would be appreciated. And
But company is a limited liability company. We do not advocate for that. If you create a for-profit entity, the chair, you can own the entity. That's not considered working. But chair is a work authorized position. So a for-profit entity wouldn't work. So we advocate for creating the nonprofit research organization before you graduate, because you can legally volunteer as the chair, director, and the CEO. So if you create a for-profit entity, you would just own it. You wouldn't work for it. You would not be the chair. You would not be an officer of the entity. You would not sign any documentation. You would just be the owner. In our case, our solution is you can create the tax-exempt organization before you graduate. You can be the chair, you can be the volunteer CEO, and so on. The second part of that is, from what I understand, students need an employer to sign documents. When you're an F1 student, the DSO is your primary supervisor. So we would obviously want you to yield to their supervision. If you need work authorization, CPT, severe economic hardship, go to your DSO regarding that. However, ICE and SCVP has come out and said, because you're volunteering for a tax-exempt organization, albeit your own, work authorization is not required.
Okay, sounds good. So next question is, how can I sponsor myself for an H-1B visa? I guess we can talk from both sides, from the Cap-exempt H-1B or from the regular H-1B also.
Well, it's both. The only process for cap subject is the random selection in March, and it's only available for 58,200. The ones that are not used by Chile or Singapore, then they come back into the pool. Then you have the additional 20,000 for advanced degree. But H-1B cap exempt is available. And if you look at the language, both for the wage selection that's been proposed to change, it says very clearly, if there are fewer registrations or fewer registrations for H-1B cap subject, that all petitions will actually be selected. So it actually is possible that everyone shifts from cap subject to cap exempt. And if everyone were to do that, there would be no need for cap subject. Now, specifically to the question, since 1958, reaffirmed in 1980s and so on, there are specific precedents, as we described earlier, that say the corporation is separate and distinct from you. And in the eyes of the law, is considered a person. You are in charge of that entity, and you're legitimately the officer. And then you can legitimately sign the documentation.
Okay, sounds good. Moving on, this person wanted to ask, how would I pay myself through my own firm for H-1B if I'm struggling by myself? Can even the firm which does not have any revenue still file for H-1B?
So there is a WHD wage hour division discussion about this. Technically, the H-1B employee in the United States does not need to be paid for 60 days. So that gives you a little bit. Keep in mind, this is future work authorization. When you create the entity, generate the EIN, file for recognition, you're not employed that day. You file the LCA for an intended period of employment in the future, up to 6 months from that date. So that gives you time to, and I'm not saying it's easier or simpler with a tax-exempt organization, but it creates opportunity for you to fundraise differently than you would for a for-profit entity. And then with respect to paying the prevailing wage and so on, nonprofit research organizations are actually able to choose a survey of other entities in the same area of intended employment. So technically, the nonprofit research organization is not subject to the prevailing wage in that new proposal. And if you read it clearly, there's actually no mention of cap-exempt employers in that proposal. And so the payment, the entity would choose with the Employment Development Department, or if you're outside California, the appropriate agency, and you would set that pay cycle, because that's important, because current employment, you have to have 2 pay stubs. So you might want to set your pay period as 1 week so that you can work for another entity after 2 weeks. And then you have to have medical, dental, and vision benefits. And with a tax organization, you can raise those funds earlier.
That's helpful information. I think some of the details some of us might not know. So if you wanted to get in touch with our expert for today, definitely feel free to scan the QR code on their screen, or scan the QR code with Go Elite. We'll help you connect with their emails as well. So moving on, next person, I think some of us in the audience is some might be more familiar with the term H-1B cap-exempt, some might be not. So can you just briefly tell us how is it different from the H-1B that everybody knows about?
Sure.
What's special about the H-1B cap-exempt?
And Tony, you want to take it?
Well, this question is kind of different because cap-exempt H-1B kind of refers to income. So if you're like being paid below income, that's what that's about. But if we're talking about H-1B cap-exempt, you're exempt from the cap, right? So the limitations, and you can be petitioned for it year-round instead of having to depend on March. So
the process is the same forms, labor condition application, ETA 9035, the I-129. The only difference between cap subject and cap exempt is everyone's focused on getting cap subject. F1 students don't realize that they could actually, if you're doing cap subject, you can actually create your for-profit entity before you graduate. The current system, there's no requirement to have an employment offer to file for H-1B cap subject initial registration. It's just basic information about you, the employer. There's no discussion about the position or your degree. Obviously, that may change with the current administration, but a lot of F1 students are not aware that they wait until they get their OPT, which may take 30 days to 90 days to get. And then some of them may be immediately unemployed, and then they're just scrambling to get work. And then a lot of them don't understand the prevailing wages, so they just accept whatever offer. So that employer may say, hey, we'll file for you at level 1 when it should be level 3, level 4. So again, in contrast, cap subject is specifically 58,200, which is generally available for more than 20 million employers in the United States, very statistically small. Cap exempt is available. There's only 1.3 million organizations that are available. So think of the odds, 58,200 versus unlimited. It's actually underutilized. Last year, only 6,500 cap exempt petitions were filed.
Mm-hmm. Absolutely. Next one will be focused a little bit more on the concurrent side. So can you explain a little bit more about concurrent H-1B and what are the eligible criteria if I'm going to do H-1B on a concurrent basis? And then in terms of resources, how can people find more resources to research to study this program?
Sure. So with respect to
that is
go ahead.
Sure. So with respect to that is
Go ahead.
Sure. So with respect to
I have an echo.
Yeah, one moment.
Oh, sorry, there we go. I had
Okay,
okay,
now we're good.
Go ahead, Antonio.
Oh, well, I could tell you where to find more about the program. That would be on the USCIS website. I think Rauhmel's slide for concurrent H-1B kind of covered a lot of the topic.
Right, but there's also a WHD fact sheet, 62W, that discusses who has applied. So that's one way to look at it, is look up there's actually a H-1B topical index, which has all of the discussions from the Department of Labor side. So portability, and which is there is a specific definition under the American Competitiveness Workforce Act, Improvement Act, excuse me, ACWIA, that discusses where that rule came about. But with respect to 8 CFR 214.2H, the program rules, it just discusses that once you are approved as H-1B, whether it's part-time or full-time, you are authorized to start concurrent employment. The language says upon the filing, but the reason why we did that graphic so that you can see that the LCA takes 7 working days. That could be 10 calendar days. And then you have to have 2 pay stubs. A regular employer might be doing pay stubs on a bi-monthly basis. So you're talking a month before you might be able to, that entity can file, or that company might be filing on a monthly basis or a quarterly. So that puts it out even further. And then with respect to the concurrent employment, the entity must obviously be a regular employer, meet the definitions. And then the specialty occupation has to be defined by the Occupational Network Employment Group, the specific occupations with a code, which is used for prevailing wage. And then the Bureau of Labor Statistics, they have something called the Occupational Outlook Handbook. That's not every job is in there. Occupation is listed, and it has to say your degree is required. It's the same for the regular petition.
Sounds good. A lot of wonderful resources. We'll make sure that we can put something together and send it our way to our audiences. So thank you so much for sharing. And the next question is a little bit of follow-up to the proclamation. So will, obviously no one had the 100% answer for that, but
I do.
To your opinion, so will the 100K apply to Cap-exempt?
Again, it's for outside. The language is sort of mixed. It doesn't, again, it's silent about cap-exempt employers. It focuses on the H-1B cap lottery next year. That won't happen until March 15th, March 17th, 2026. And then those persons would have to be identified outside the US. So right now that group has not been clarified. Regarding again, the beneficiary, this is not a concern for you. That's on the employer. So as a beneficiary, this is not something you worry about. You go through the whole process of being recruited and so on. And if that employer, if you're outside the US and it's for cap subject, then yes, that employer, NVIDIA, has pledged that they're going to file. So as a beneficiary, don't worry about the $100,000. That's for the petitioner to file. That fee would not even be borne by the beneficiary. So to be quite honest, so the answer there is, as a beneficiary, that's not your concern.
Okay. All right, moving on. How long does it take to get approval for the H-1B Cap-exempt?
So we discussed the 24 hours to create the entity, 15 minutes to get the EIN. The wild card is how long it takes to be recognized by the IRS. And then Once that is approved by the IRS, then you file the LCA. That takes 7 working days. And then the premium processing. So you're talking around 30 to 45 days.
Okay. Sounds good. So next one, how do Day 1 CPT University help students become eligible for H-1B? So I think I can take this question. So
You go first and I'll piggyback.
yeah, for sure. So for Day 1 CPT University, so most of them do have career services. So I think right now, for students, their first stop will be trying to find a employer who can sponsor their H-1Bs. And then if they can identify a career opportunity for the students, if the students are recruited and become an employee, and they can later be eligible to file for H-1B. Obviously, some of the students are in school, might also start their own businesses, but I will let Rauhmel chime in on the H-1B Cap-exempt side.
So keep in mind for Day 1 CPT, that means that it's an advanced degree. That means they already have an undergraduate degree. So the universities could invite us to train them, and they can actually create their employer before they graduate. And then H-1B allows you to go to school full-time or part-time. So you could actually switch your tuition fee level and complete your degree there. So the answer there is you already have an undergraduate degree, create the cap-exempt employer, file for H-1B cap-exempt, and then go back to your admissions officer and switch the fee rate. Because F1 students pay high tuition rates.
Okay, sounds good. Thank you for your tips. And then moving on, what advice would you give to F1 student planning for the H-1B 2026? Obviously, we talked a lot about the starting company, H-1B cap-exempt side of the things, but just in general for everybody, I know is a little bit unsteady for H-1B right now. So what would be your tip for F1 student trying to go for H-1B next year?
So it's pretty, to clarify, it's pretty steady. The laws haven't changed, the regulations. Keep in mind, he did a proclamation for the $100,000 fee. It was not an executive order. So there's different language for different reasons. So there's no laws have changed. So we are a nation of laws. That is still in place. So again, for an F1 student, prior to graduation, contact your DSO, make sure you're eligible to get your OPT before you graduate on time. There have been some F1 students who are trainees who get delayed because it may take up to 6 months. So the opportunity there, we like freshmen or Day 1 CPT, their first year of their master's program or their PhD program, because they can create the tax-exempt organization and generate revenue, stockpile it, and then when they're ready to hire themselves, they can do that right away. So for those doing cap subject, I think there's a cap subject question because cap-exempt is available now. So if you want to do this, we wouldn't be focusing on 2026. But that would be for cap subject. Again, you can contact employers before you graduate, and if they're willing to put your name in the hat, or in this case, with your own organization.
Okay, sounds good. All right, moving on. Can we work for another employer as full-time? This is related to the concurrent side of the H-1B.
Antonio, you can take that.
Yes.
Short answer, yes.
Yes. That's my short answer.
So could you share a little bit more?
It doesn't say 1 concurrent employment, 2, 3. That's called bridge petitions. So as long as the first one is anchored to your entity on a part-time basis, the second employer, third, fourth, fifth employer, you're allowed to work for all of those. Again, that's why I mentioned about the employment agreement. That second employer may stop you from working for other. They may say, hey, you know what? We're paying you so much money. We don't want you to work for anybody else. So that answer right there is up to your employment agreement.
Okay. All right, moving on. So what would be the cost for this process, I guess, to go for the H-1B cap-exempt and starting from ground zero?
So California costs $30 to create a nonprofit. Tax-exempt status is $275. Obviously, you need an office that can be visited by the government agencies. So you would have to plan for getting an office that can be verified by DUNS as well as LexisNexis. And then with respect to the EIN, that's free. So that's your basic eligibility as a United States employer. And then with respect to the petition itself, tax-exempt organizations pay $460. And then we are waived from the ACWIA fee. So there's no requirement to pay the $1,500 or the $750. And then the fee that is not waivable is the $500 fraud detection fee. So you're talking less than $1,000 that you could do this yourself. Now, if you're going to train with someone or you're going to hire someone to do the process for you, as I mentioned earlier, our trainees train for a year. They have to learn how to run the organization, manage volunteers, publish apps. There's a range of stuff. Filing an entity, to be quite honest, is not that hard. That's why we do the free sessions like today.
Okay. Thank you. Very informative. Moving forward, do we need to work for only nonprofit, I guess, for the H-1B Cap-exempt?
You want to take that one, Antonio?
I can take this one, yeah. Dan, the short answer to this is no. Your first organization has to be a nonprofit in order to start bridging, like Rauhmel has said to in this slide. So you can start working for a nonprofit, and then afterwards you can start working for NVIDIA, Google, or whatever else. It all depends on the contract agreement.
Now, if your employment ceases, now obviously you wouldn't fire yourself.
Right.
But if so, you anchoring your authorization. If you were to fire yourself, then you would become cap subject and you would have to wait to October 1st, that whole process we described earlier. So the beauty of the solution is the language about controlling the beneficiary, all of that has gone. It's this generation benefits from a new opportunity. From 2010 to 2020, USCS did an overly interpretive assessment of the hire, fire, pay, supervised criteria. And in the old days, we had to meet all the criteria. Then it changed in June 17, 2020, where you only had to meet one criteria, and now that criteria is gone. Filing the LCA is evidence of an employer-employee relationship.
Sounds good. Thank you both. Moving on, I think this question will kind of quite cover this already. So it's mainly about H-1B Cap-exempt differences between the H-1B cap subject. So unless if you have anything to add, we can skip this question.
Well, the opportunity now there is a stark difference between cap-exempt, cap subject with respect to cap-gap work authorization. If you the new rule allows for an extension for OPT and STEM OPT authorization if you have a petition for cap subject. So cap gap extension is available only for cap subject petitions. Because cap exempt is available now, that's not available for cap exempt. So that becomes an issue where if you wait to the last minute and maybe you want to continue OPT or STEM OPT, well, then obviously cap subject will be an advantage there. Unfortunately, we had a scenario where we did file for cap subject and we had approvals before and never had an issue. We did have a U.S. officer say, hey, cap exempt should only be filing for cap exempt. He did file, refuse that petition, and then that person lost their status. So we do have a fresh example where cap subject does guarantee the cap gap extension, cap exempt does not.
Thank you.
I also want to add on to that, since it says other option and doesn't really specify. The other option, I guess, compared with cap exempt, that has no limitation is the O1, the extraordinary visa. And as you can see, as you probably saw from the presentation, with the O1, you have to meet 3 criteria, whereas H-1B cap exempt, well, you just have to have a bachelor's degree. So there's that.
And then one additional thing there is if you are going to go the on-one route, my trainees or our executive trainees, you can do that with a nonprofit research organization.
Okay. All right. Thank you both. Moving forward. So this question, I think is a great question. So if I'm already on H-1B visa with the company that was previously, I assume that was previously cap subject. So I got the H-1B from a company. Can I still start a company and sponsor myself with the new cap-exempt the new company?
You want to take it, Antonio?
I think that would go back to the employment agreement that you would have with your employer.
So if you're already on H-1B, H-1B is not an EAD card. OPT is. So when you're OPT, you can do a range of things. When you become H-1B, it's employer specific. The only approval you have is the I-797, which is notice of action. So therefore, you do have to talk to your boss, your supervisor, and that employment agreement, that's when it's critical. And again, some employers will tell you right away, you are permitted to be the director and officer of a nonprofit because it's a different industry. But again, they'll have, because you are getting access to intellectual property, confidential information. So they really don't want you working for another. So you have to be careful when you say, hey, I want to start a company. Again, company is an LLC. We don't recommend that. There are additional steps that an LLC would have to take to be treated as a corporation. The owner, the sole member would have to give up its right to a board of directors. It can still name itself as a sole director, but there's additional steps there. So we don't focus on LLCs or companies. We use the terminology corporation or United States employer. And then, as Antonio alluded, look at your employment agreement. If it says you can't work for another person because we pay you a lot of money, then you need to stay with us. And if they want green card, then that's a decision you need to make. You can change employer. And the beauty of this is you can start generating evidence for the EB-1A.
Thank you. I just want to add a follow-up. So what about if the person is thinking about exiting the company, like exiting the current positions?
Sure. So we want to be careful there. If you're fired, then that becomes an issue with the what is called immediate and automatic revocation of your status. The employer is supposed to send you back home. There's a misconception that the grace period or up to 60 days is guaranteed and that you can loll around and do what you want. That's not how that works. USCIS updated the new rules, and it says very clearly, the moment you're notified you're no longer employed, your status is over. So if you want to keep your status or preserve your work authorization, that second employer should file before that petition is canceled or revoked. Does it make sense?
Yeah, yeah.
Okay. And then so then in that way, but if you don't get fired and you quit, there's actually no grace period. It actually says that in the rules. There's no grace period afforded to a person who quits because it's a different scenario than you being fired. So that is an opportunity. Again, you would want to do it before because the new rules say, and the scenario says if you're told you're no longer employed, obviously the converse would be true. If you quit, then your status is revoked because it's contingent on that employer. So we strongly train our trainees to file before they decide to quit that employer.
Okay, thank you so much. Next question, similar to one of the previous questions. If I'm on CPT right now, can I go ahead and start the company?
So the CPT is part-time or full-time. If you're slated to work, maybe it's part of the internship or so on, and a specific employer, then follow that advice of your DSO. Part-time is what the opportunity, and you can have multiple CPT. This because the DSO has the authority to sign that. So we would obviously, as I mentioned earlier, we like freshmen or a master's program as soon as they start school to create their own employer, start stockpiling that, getting experience, and preparing before they exit the school program.
Sounds good. Next
now,
question.
the DSO does not have to, so keep in mind, the DSO does not have to prove that.
Absolutely. So next question, this person wanted to know, can I work for my own startup company if I'm starting a company on F1 visa, right? I started my company. Can I work for that company and get income possibly?
I'm going to let Antonio. We just went over this yesterday. Go ahead. What's the answer?
Are we talking about for-profit or non-profit?
For-profit.
For-profit? If we're talking about for-profit, you can volunteer for your own.
This is for-profit, not non-profit. This is for-profit.
Oh, right.
Read the question.
Can I work for my own startup on an F1 visa?
What's the sole purpose?
The short answer is no, because you come here to study, and then after you study, you're supposed to return back home. So
what that means is it's called qualifying F1 students under the Foreign Affairs Manual. You told that U.S. consular officer that upon completion of all your activities, that you had adequate funds, that you would not go to work, you would not do side hustles, that you would go back home. Now, obviously, things change over time. However, it does says very clearly, CPT, OPT are authorized, but it's speculative. We don't know if you're going to work. We don't know how much money you're going to earn and so on. So that's a question better reserved for the DSO. If your DSO, because they're concerned about unauthorized employment. Now, you might get approved for doing something and doing it on the side and no one finds out. But when you try to adjust your status, then that's when there's more scrutiny is going to happen. And if they find out that you worked for 6 months when you weren't supposed to, then you're going to lose that opportunity to change your status. So that's why we advocate for the tax-exempt organization, because it doesn't run afoul of unauthorized employment.
Okay, sounds good. All right, moving on. This person's questions is more, he wanted to focus on the angle of stand OPT. So we don't really have a context of the questions, but let's just assume that if it is stand OPT, would that make a difference to apply for H-1B Cap-exempt compared to—
So the context is that OPT, you could be a self-employed business owner. STEM OPT, you still have to be E-Verify. However, the issue there is that you have to have a personnel providing the training experience. So obviously a STEM OPT person can't train themselves, which is why we alluded that we are available to train you as the contractor to provide that experience and supervision. And then we can sign the 983. The restriction there is that another F1 student can't supervise another F1 student. So there's 2 restrictions there. There is an opportunity for alternative compensation on the 983. So specifically the answer to the question is STEM OPT, you can still be the business owner or the officer and so on. The issue there is your training, the T in OPT is training. So you're supposed to be training. That means you can't train yourself. Someone's got to do that. So if you have an outside contractor supervising the training and so on, that will meet the definition. And then you can still keep your own entity and work for it.
Next question, I think there's some kind of a typo. It's not Cap-exempt OPT. So let's just assume that H1B.
H1B, yeah.
Yes. If
I think here is this is called a change of status. So cap subject, keep in mind the start date will be October 1st or later. H1B cap exempt obviously will depend on the LCA. Think of it like a request date. USCIS can either approve that date or change it and make it less than what you asked for. So you will lose access to SEVIS once your status is approved. So that's called termination reasons. You looked at under the F1 student status website, and it says very clearly, if you change status, you will be locked out as an F1. Obviously, inform your DSO what's going to happen. And as we discussed earlier, you can finish, you will no longer be STEM OPT. It'll be over. You'll start from that date. So you do have to be careful about the dates because you can file right away. As I mentioned there, if you're really good at it, I've gotten it done in 5 days, but that's hustling.
Okay, thank you for your information. Next person just wanted to know that how can he approach you guys for a one-on-one session?
Sure. So as I mentioned, I'll be offering a session during LA Tech Week on Saturday, 10 a.m. to 2 p.m., 12 p.m., excuse me. I'll be available during TechCrunch. Then we'll also on our screens here, I think. You can download my information directly to your phone, and then Antonio's is there as well. And then certainly contact Ryan, and then we'll figure out, as I mentioned earlier, maybe a follow-up session, or we can do either in person, or we will figure it out.
Yeah. If you wanted to send us an email, we'll also refer you to.
Sure. So it says here, so he's working for, I'm presuming state org might be either a nonprofit or a government agency. The issue there, so go back up a little bit. He says he would like to continue his employment. To clarify, STEM OPT is training. So if the other STEM OPT, the wage level, the work you're doing, when you switch to H1B, it's supposed to be H1B caliber. You're not supposed to be doing the same level of work and so on. So I'm not quite sure what he means by continue the employment. Again, STEM OPT has a limit. It cannot be extended. And if you want to continue employment maybe to cap exempt, then that employer, that would be a scenario where create your own organization, file for part-time, and then you can work for that organization. But again, that will fall under the prevailing wage.
Okay, thank you for the information. Next one, it seems that only nonprofit organization directly affiliated with higher education institution can qualify. Is that true, first of all? And then the second is, what strategy exists to overcome this hurdle?
Sure. So there are actually different institutions of higher education are in one group. Nonprofits affiliated with those institutions of higher education is another group. Nonprofit research organizations are standalone. For-profit entities can maintain a relationship with an organization like ours to claim eligibility. So that's another group. And then there's a group, you have your schools, high schools, stuff like that. And then you have providing clinical training for nurses and doctors. So there's actually, that's a large group. Of all that, we don't recommend the nonprofit affiliated scenario because that scenario, the higher education institution can hire its own. And you bump into dependency rules. There's no minimum investment to create the entity. You don't have to recruit U.S. citizens. But if that institution of higher education is a dependent employer, then they have to recruit U.S. citizens first. So that creates some issues. Nonprofit research organization is standalone. So that's why we focus on that. I wouldn't see it as a hurdle. It's just a path. If you're going to work for a college, typically you are doing some kind of research project. Some of my trainees are doing some great stuff that they've got research grants and want to continue that project that they were working on. I get that. But once you get outside of the educational institution, then you get into nonprofit scenarios. They're there. But again, nonprofit research organization is standalone. So that's why we recommend doing it, because you can use concurrent employment to work for anybody else.
Okay, thank you, Rauhmel. Moving on. Next person. This question, I don't know if this is relevant. I don't know if you guys know how about this, but the Office of the Citizenship and Immigration Service Ombudsman. So
what happens is if you have a petition, and this is a little bit outside the scope of today, maybe there's a petition. Beneficiaries are not able to communicate with USCIS. So this is if a petition is taking too long. You can contact the ombudsman to advocate and so on. That would be whoever files the G28. The attorney or the accredited representative will be communicating. That's in a case where someone is they're concerned that maybe a petition, this is really more for employment-based, where it's taking too long, then the ombudsman can advocate for that petitioner. But that's outside the scope for F1, STEM OPT, and stuff like that.
All right, next question. This person wanted to know that can I work for 2 employers on CPT? I think the answer is yes, but you do have to have your DSO's approval on that. And then does my primary employer needs to know about my second employer? And if so, what's the details should they need to know?
Antonio, what's the answer? Employment agreement. If the employment agreement says you can't work for someone else, then or you need to ask us permission. So read your employment agreement. If it's very loose, like it doesn't say you need to tell us anything, then you don't need to tell the second employer. But if that first employer wants your time, they want your resources, they want you on call, they're paying you a lot of money to do that, you may be doing something critical, they don't want you working for someone else. So the employment agreement controls there.
Okay, next one is clarification questions for the 100K. So if an F1 student is currently in US working for a Cap-exempt employer, will the 100K proclamation apply for new fillings?
Again, the 100,000 is borne by the petitioner. So again, beneficiaries, this is not something you need to concern yourself with. So stop worrying and being anxious about that. The $100,000, the president is authorized to set conditions on entry into the United States. He's not authorized to change policy inside the United States. So for the person inside the United States, there's no effect, no change. The law still remains the same. Petitions are still being adjudicated and approved or denied and so on. This goes into the future lottery for future U.S. degree holder outside the United States who've been identified and recruited in March. That person won't be known until March 31st. So right now, that's all speculative. Again, the $100,000, if it holds after the 2 lawsuits, then that petitioner will pay a fee, either PayPal, ACH transfer, credit card. There's actually ways to do that right now. So a lot of attorneys and so on are saying there's no mechanism in place. That's incorrect. The DHS has the ability to collect funds above a certain amount of money. That's in place. The State Department just needs to check that you've made the payment. So again, the petitioner will file the $100,000 prior to filing the petition. It's called a counselor request. They'll check a certain box under section 4 of the petition. And then a petition will go to the State Department abroad, and that's a whole different process. But again, that's only for counselor processing for someone selected in March 2026.
Sure. Next question. This person wanted to know more about the dependents. So how would the H-1B Cap-exempt be affecting their dependents? Would they be the same as any other H-1B?
So H-1B is permitted to have H-4 dependents. The 2 opportunities there. One, the primary holder can obviously file for file simultaneously petitions for H-1B dependent. If that person files for I-140, as we mentioned earlier about EB-1A, and gets approved, then the spouse can get work authorization. The Supreme Court just refused to accept a challenge. So it's now cemented that H-4 dependents can work without all of the criticism that's been going on. The other opportunity is for, particularly from Indian nationals or Chinese nationals, if they're aging out and their child is 21, the child can work for the United States employer and go H-1B. They don't have to go back to F1 or self-deport.
Okay, thank you for the information. Next question, if I'm employed by a specific company, I can only work for that company, or can I make any side hustle? This has to be very specific with type of visa that you're on. But let's just assume that if this person wanted to talk about H-1B visa.
Sure. So let's go backward from EB-1A. One of the options for EB-1A is high salary or remuneration. So you want to put yourself in a position to do that. If you own a corporation, so for example, I want to get paid to give a speech. Well, that's considered part of my compensation. If you're just an employee working for, XAI and you're getting $300 million a month, that's a great salary. But if everyone is getting $300 million a month, then that's average. Does it make sense? And so the petition here for side hustles and so on is H-1B is only for that employer. The new law or new regulation does allow that if you are a beneficiary owner, you create the for-profit and you get approval, you can now be the other positions of the corporation. So you can be paid as a CEO, you can be paid as a director. Those can be your side hustles. This kind of side hustle is, I want to operate Airbnb, I want to drive for Uber. That's not specialty occupations. So the side hustles typically tend to be, I want to just get some extra money. H-1B is based on specialty occupation.
Okay, thank you so much. So, due to the timing perspective, we still have lots of questions to go.
We got
So
time. We're good.
yeah, hopefully we can do a couple more,
Sure.
and then in the future, if we wanted to do one more session also, and our audiences can ask more questions. So
Sure.
let's just do two more. So this new nonprofit has to be formed when you are students, and it could be filed on standard OPT times and secure H-1B.
That can be a time. Let's go through real fast. Q27, anytime you can file. Q28, can you kindly send me the employer list?
Except university and college, which employee H-1B exempt employee,
I
which
think that's for
accepts
you guys,
H-1B accept.
for Go Elite. Maybe you guys provide a service for the day one CPTs. Q29, so can I have an exempt H-1B and CAPS at the same time? Again, if you're employed with CAP exempt, it's not CAP subject. You're not subject to CAP subject. You can work for any other employer that's considered CAP subject. Q30, can you travel outside the country? You need, you'll have status and work authorization. You won't have a visa. So there's a mixed question there. You'll have status if you need to go outside. Obviously, you need to get a visa. There's some speculation that the current proclamation doesn't cover that because, again, the money has to be filed before the petition's filed. Obviously, you have approval, so that doesn't match. Q31, does CAP exempt need another work visa to work for the employer? CAP exempt is specifically for that one employer. If you want to work for the other company, that would be concurrent employment. Q32, if I'm working for multiple employers, say 2 employers, would the only company need to file, again, they wouldn't file CAP subject, they'll file the same forms. They would just choose that the petition is not subject to the CAP because you already have work authorization. Q33s, if you say I'm on CAP exempt, I'm also eligible for working with another like Google, Microsoft. Correct. If you are CAP exempt with your organization, you can work for any other for-profit entity or nonprofit entity. But again, if you were working for another nonprofit and they fire you, then you would have to go through the lottery. But you're working for your own entity and you're not going to fire yourself. Q34, if I'm on an H-1B, can I work for another organization, a different role? Again, a specialty occupation, it has to require your knowledge. So you can't be computer science and then switch over to accounting. You don't have that. If you have those 2 degrees, some day one CPT students do. That would work. PhD have 3 degrees. That would work. But a bachelor student, probably not. I'm currently working for a company full-time using my first year OPT. Is there a chance for me to do this? Yes, you'd have to do right away. We'd have to look at when your OPT expires. If you have pre-completion OPT, then your OPT is expiring quicker. If you have regular OPT, then that's going to probably expire, obviously, before next June. Can H-1B holder set up his own company to sponsor EB2, EB3? Yes, you can have multiple petitions for any employment-based category. You want to get your priority date? Some will do EB5, or excuse me, EB4, EB3, so they can switch up to EB2, NIW, and EB1. Where can I find an employment agreement? That will be given by the employer. Or you can search online. ChatGPT can give you an example, but that will come from the employer or your HR department. And lastly, does CAP accept H-1B provide support dependents to stay legally? Yes, you can. H4 dependents. All right, we covered them all.
Okay, rapid fire. That was amazing. Thank you so much. We answered all these questions. And then I think this Q&A session has been very helpful. We have tons of questions from different angles. So thank you both for being present and sharing your knowledge with all of these audiences. And I hope everybody did learn something from today. And then thank you for your presentation and the Q&A. And I hope everybody have a good night.
Sure.
You too.
Thank you.
Bye.
Okay, thank you guys. Thank you for attending. Thank you, Antonio. Thank you, Rauhmel. I'll see you guys soon.
Okay, bye.
Bye-bye.